Crime theory talks about the idea of mens rea and, of course, mind that talks about the entire plot of offenses. Talking about offenses, there are two basic forms of offenses, and the differentiation and bifurcation that we talk about comes under section 436, talking about bailable offenses. These are the forms of offenses which are not that rigorous in nature, and the gravity of the crime is not that high. For example, theft, defamation. On the other part, the non-bailable offenses are the one which has the punishment starting from 3 and above 3 years of imprisonment, and that talks about other parameters where the nature of offenses ranges from murder, rape, and other grave forms of offenses. The furtherance to this is anticipatory bail and, of course, the permanent bail. So, summing them up, all four of them, we have the basic four forms of offenses where a person can be given the chance of not coming before the court and still he has been allowed to be free. That is what we talk in the idea of anticipatory bail. Similarly, we have bailable offenses where the person is set free after the court receives a bail bond. The bail bonds are the one which are the amount that is given in lieu of setting a person free. However, that is definitely a discretionary power of the courts that can set a person or accused be free or not, and that depends on the criminal history of the accused person. On the other part, the non-bailable offenses are the one which are very gruesome and very harsh in nature. So normally the bail bonds are just not the only parameter to set the person free if he comes or the crime comes under the parameter of non-bailable offenses. Lastly, we have something called permanent bail. Permanent bail is something which is granted by the court after listening to both the parties. Thank you.